So people are not understanding that. Okay, so so today's purpose is to aware you, and if you feel any issue, if any question in between the presentation, you can ask, because it is for you only. So I will start my presentation. So first of all, this is the brief overview of Intellectual Property Office. We have patent and design filing offices in Kolkata, New Delhi, Mumbai, and Chennai. If you want any patent information system, we have office in Nagpur, for the training related purpose also. We have trademark offices also in Mumbai, Kolkata, New Delhi, Chennai, and Ahmedabad. And geographical indication, this office is in Chennai. We will deal each one intellectual property one by one in details. This is our office in Mumbai, Chennai, Delhi, and Kolkata. Okay. And this is Nagpur Training Institute, and this session is being conducted from this institute right now. And this is our website. This is very updated website, and you will feel every time new information when you will enter into it. And whatever the slides, whatever thing I am going to present, all things are available under this website. So, and we have updates on social media. We have Facebook and Twitter account also. And every day when you will visit it, you will get new information daily. And we will also share, if you will share your photograph with us, then we will also put our today's program in the Facebook and Twitter for the record of the office. We are also conducting a classroom offline 1 week skill development training program. It has to be conducted from 22nd to 26th August. Timing is from 10 o'clock to 6 in the evening. And the fee structure is 2,000 per day per participant. Minimum 2 days is required. This is offline program. There is 50% concession also, in which these points will be addressed: patent filing procedure, patentability form fees, patent specification, how to write specification, case studies, patent search, IPC, hands-on exercise. So these are the list. Okay, if you want, if any of you, you are always invited to join this program. You will get the further details on the Facebook and the Twitter. Okay. Now we start with the topic. What is intellectual property? So there are two points. First one is intellectual property, and second one is intellectual property. So for that we have to understand property. I know that all of the person has certain knowledge about the property. Property means something for which you have a legal right. Okay. The thing is that who will give you the legal right? The statutory, the legal, the government. He will give you the legal right. Okay. And of course, you will take the legal right for which there should have some commercial gain, some commercial benefit. Otherwise, no need to gain the right for that. Okay. So that is meaning of the property. Now come to there is also another addition, that is intellectual property. So for this property also, you have to take the legal right. Okay, who will give the legal right? Again, the Indian Patent Office, the statutory body by the government, that will give you the legal right. Okay, and this is given for limited period of time. Of course, property is for the if you have purchased any property, it will be transferred from one generation to another generation. But for the intellectual property, it is for 20 years in the case of patent, and in the design in case of 15 years. Okay. So it is a completely product of mind. Product of mind means when your good mind combines with your knowledge, combines with your experience, then you can enter into the arena of the intellectual property. Let's suppose that I am selling one example of the Japan, that there was one lady, and and she was a household lady, and since the Japanese generally used to eat the rice, Rice are generally sticky in nature. They always used to stick on the spoon. When she used to take this rice from the spoon, all the rice used to stick on the spoons. So what she did, she made spots, so many spots on the spoon, both side of the spoon, and that made easier to take the rice. And the rice, the percentage of sticking was too very less. She patented that technology, and she earned millions and millions of dollars from that. Okay, her husband was a lawyer, and he told that in whole life I didn't earn so much, but one your single invention has has changed the life. Again, you have seen that bottle. You will see in this slides also. There are very small thing. The thing is that how the idea should become, how you can come with an idea. Okay, that is important. Now, intellectual property, of course, is the property which arises from the human intellect, and it is completely a human creation. Okay. Now, this is the slight background of the intellectual property. One thing I want to say, when you will move behind 30-40 years, in that case, there was a demand of property. If you have a property, you will be known as a good personality. But nowadays, things has been changed. Now it is the world of intellectual property. Now it has been asked that how many intellectual property you have. Okay, so more and more intellectual property, more and more technology you have. More, most of the foreign delegates, ministers, they are meeting on the regular basis for the purpose of technology transfer. Bullet train is going to be made in our country. That is also technology transfer. Metro is also going to is running in our country, but nobody is ready to share the technology. Okay, so technology transfer is very important thing. So that's why I want. It has been said that intellectual property is gaining too much importance nowadays. Okay. See, so in generally we can say that properties are generally of two types: tangible and intangible property. Tangible property means cars. Immovable property means building, plot, shop, houses, land, anything. Intangible means it is related with completely intellectual property, and it has been divided into two parts: industrial property and copyright. Industrial property means patents, design, trademarks, and geographical indications, and other one is copyright. We will deal each one of these industrial property one by one. So now we have understand what are the intellectual property. These are intangible creations. These completely human intellect. It is not combined to this thing only. So students are there. They will take their management degree from this college. That is their also intellectual property. So it is, we cannot combine on up to this thing only. Okay. Anything which is the creation of mind, that is the intellectual property. So, but we are here to discuss regarding the thing for which more awareness is required. Okay, and it should have some commercial value. So the thing is that when you look, suppose I talk about patent, when you look technology in terms of a legal angle, so intellectual property means legality will enter into the market. You have heard that recently the Cadbury has got, the High Court has given the fine of rupees 10 lakhs to an Indian company who has stolen the trademark value of the Cadbury. They have taken the Cadbury trademark, and they were commercializing that thing. So they have fined 10 lakhs rupees to that company. Okay, this is the recent news. Now come to the what is the intellectual property right? So thing is that you will get when you will get the right, you will get three types of right. One is exclusive right, other one is territorial right, and after that there is licensable right. Okay, so exclusive right means the right which given to you. Okay, for against 135 crores of Indians. You will get the right. You will create a red ocean. Nobody can enter into that ocean. If you have any technology, you have any right for that. Nobody can enter into your arena. They have to take your permission. Okay. Second thing is that is a territorial right. Territorial right means if you have filed your application in India and you have got patent certificate or any industrial property right here, so you cannot stop anybody in Bangladesh, in Sri Lanka, in China, in Pakistan. Okay, you cannot stop them. For stopping them, you have to file your application there also because it is a legal term. And legal is law is different in different countries. It changes from one territory to another territory. Okay. Another one is you will of course you will get the licensable right. If you have the right, you can transfer your invention to other person also. You can license them for a certain period of time. Okay, this is the definition of the patent. Patent is an exclusive monopoly privilege granted by the government to whom? To a patentee for the limited period of time, 20 years of the time, for gaining the commercial gain. Okay, and since you can ask that if government is giving too much thing to an inventor, then what? Since government works on the behalf of a public, then what is public is going to get? So public is going to get the full disclosure of the invention. The inventor has to give the full disclosure. Best method he have to disclose to how he have performed that invention. You know about Thomas Alva Edison, he has invented the bulb and he has taken the patent for that. So instead of that, he disclosed his invention that how I have made it. So the person skilled in the art who is working on that field, by reading that document, he will understand that how a bulb can be made. He has not to start with the scratch. ओके उसको जीरो लेवल से स्टार्ट नहीं करना होगा, उसके पास कुछ इंफॉर्मेशन होगी और वो उसमें मोर एंड मोर एडवांस टेक्नोलॉजी अपनाएंगे एंड ही विल move ahead. So it is a kind of also technology exchange. If India allows the foreign inventors to file their patent in India, so of course we are gaining more and more technology from there. अब रीजन क्या है कि आफ्टर 20 इयर्स वो पब्लिक प्रॉपर्टी हो जाएगी. 20 इयर्स के बाद उस पर कोई भी रॉयल्टी वो क्लेम नहीं कर सकता है. सपोज दैट वी आर यूजिंग पैरासीटामोल टैबलेट. ओके, दिस इज दिस इज अवेलेबल इन एट अ वेरी चीपर प्राइस. Since that technology has been 20 years has been lapsed, so after that any company, even any person can make that medicine, can make that drug. Nobody will going to stop him. So that's why it is available at a cheaper cost. So this is the benefit of technology transfer. First thing is that invention patent is given for invention only, not for the discovery. So what do you mean by discovery? Discovery means something which were not in the zone of public, and somebody has discovered that, find that. So in finding there is no technology involved. Since Vasco da Gama discovered the India, but this place was known, person were known, but not known in the world scenario. So there is no technical effect in finding that. So you cannot claim anything, claim any patent for discovery. You will get anything for the invention only. So what do you mean by invention? Invention means anything which is new product. Okay, which is a new product or a process, and which has some usefulness. Usefulness for the industrial purpose, it can be used in the industry. It must be novel. Novel means new. New means at the time of filing, it is not known to any public. जिस समय आप अपना पेटेंट फाइल करिएगा, आप अपना एप्लीकेशन फाइल करिएगा, उसके पहले ये किसी भी पब्लिक को पता नहीं होना चाहिए. ये किसी भी पब्लिक के इंफॉर्मेशन में नहीं होना चाहिए. दैट इज द मीनिंग ऑफ नॉवेल. इट इज कंप्लीटली न्यू. सपोज दैट आज आप रिमोट एक देख रहे हैं, एसी का रिमोट देख रहे हैं, वो एक प्लास्टिक का बना हुआ है. कल आप एक स्टील का रिमोट बना लीजिएगा, सो वो स्टील का रिमोट और प्लास्टिक का रिमोट मटेरियल अलग अलग है। तो ये आप कह सकते हैं कि ये नॉवेल है, पहले पहले नहीं कि पब्लिक इंफॉर्मेशन में नहीं है। सो दैट इज द मीनिंग ऑफ नॉवेल। ओके। नन ऑब्वियसनेस मीन्स आपके डॉक्यूमेंट को पढ़ करके जो पर्सन उस फील्ड में काम कर रहे हैं वो ये नहीं कह सकते हैं कि आफ्टर रीडिंग दैट डॉक्यूमेंट दिस इन्वेंशन कैन बी मेड बाय मी, कैन बी मेड बाय अ पर्सन स्किल इन द आर्ट। ओके। सो वो कुछ सरप्राइजिंग रिजल्ट होना चाहिए, वो कुछ टेक्निकल एडवांसमेंट होना चाहिए। ओके। ये एग्जांपल पहला शार्पनर है। सी नाउअडेज यू विल से दैट इट इज अ वेरी स्मॉल थिंग बट इट हैज गॉट पेटेंट इन 1822। सो द थिंग इज दैट आज के जमाने में हमें जो डिफिकल्ट लग रही है, आज से 30 साल 40 साल के बाद वो चीज बहुत ही ऑब्वियस हो जाएगी। सो दैट इज द टेक्नोलॉजी, यू नो, एवरीथिंग टेक्नोलॉजी। आप 20 साल पहले चले जाइए, मोबाइल बहुत ही यूनिक चीज था, एंड फॉर इन द टुडे सिनेरियो इट इज वेरी सिंपल। सो द थिंग इज दैट हाउ द टेक्नोलॉजी इज चेंजिंग। ओके। This is bulb made by Thomas Alva Edison, and we discussed about that. This is Alexander Graham Bell telephone, first telephone. This is blue tooth device, and no, all these inventors has earned millions and millions of dollars by a single invention only. So the meaning is that if anything is there, if any information you have, अभी COVID-19 आई, इसके इस प्रॉब्लम था तो प्रॉब्लम के सॉल्यूशन में बहुत सारे वैक्सीन आए, बहुत सारे मास्क डिजाइन के मास्क आए, सैनिटाइजर आया, अब तो नोजल स्प्रे भी आ रहा है, टैबलेट भी आ रही हैं, बहुत सारे इन्वेंशंस, ऑलमोस्ट 5 to 300 400 पेटेंट्स इंडिया में फाइल हो चुके हैं कोविड-19 के इस प्रॉब्लम के सॉल्यूशन के अगेंस्ट। सो द थिंग इज दैट इफ देयर इज अ प्रॉब्लम एंड यू हैव अ सॉल्यूशन, so since it is assumed that all the institutes has robust R&D infrastructure, all are working in the all person has a certain types of intellectual property, but we have to give time on your own. When you will give time on your own, we will come with certain intellectual property within us. So these are the also famous Indian inventors. This is Tata Nano car. This is hepatitis vaccine. So since that the time has been over for this 20 years has been lapsed for this vaccine, so it can be made by anybody. So that's why it is available at a very cheaper cost. This is prosthetic leg, and the owner has earned millions of dollars. Now after 20 years anybody can make it. Now these are the small steps, small inventions. This is a baby's taking a bath. Nowadays the mobile, everybody is turning between what can be next in the sense of mobile. This is a card reader in the mobile phone. This is a new type of drone. You know, drone technology is gaining too much importance in today's scenario. This is a tree climber, mechanical tree climber made by a common person. So it does not think, but it values usability. What are the problems you are facing in your life? Okay, and if you have certain technical solution for that, so that can be patentable. Now the most common mistakes which is done by the inventors or the Indians. First thing is that they usually go for the publication of their invention or any paper. They used to go for the publication. They even don't check whether this can be put for the patent or not. Okay. So first of all, go for the protection. File your patent application in the patent office. After that, you go for the publication. Thing is that when it will be, you will publish, after that you will go that I need protection for this, then patent office will say no, because this is the novelty destroyed document. It will destroy the novelty because same document is available to the public domain, so you will not get the patent for that. Another mistake is that suppose that you have made anything and you started commercial exploitation of doing that invention. So what will be happen? Next person can also use that. He will purchase from you and he will make in his or her lab. So in that case, you cannot stop him. You should not make him because it is my technology. You cannot stop him. You have the only way to stop him by you will file your invention to the office. Okay? You will file your invention in the patent office. After that, it will become to the commercial use. ये तभी कॉमर्शियल यूज में आप उतारिए. पहले आप उसको प्रोटेक्ट करिए. आप अपने लिए एक रेड ओशियन बनाइए कि कोई उसमें एंटर नहीं कर पाए. एप्पल एप्पल के बारे में मुझे लगता है सभी लोग जानते होंगे. उसका ट्रेडमार्क लोगो है एप्पल. तो उसने ऐसा इंटेलेक्चुअल प्रॉपर्टी लिया हुआ है, ऐसा ट्रेडमार्क लिया हुआ है उसने कि कोई भी पर्सन फ्रूट के नाम पे अपनी कंपनी का लोगो नहीं रख सकता है. You cannot take orange, you cannot take pineapple, you cannot take the banana as a logo of your company. So see how much safety, how much utilization, exploitation of in the intellectual property they are going to make. So we should have knowledge, we should have certain knowledge because the world is going in a rapidly in this direction. Third thing is that somebody make an invention and they wait that when it will be fully developed, after that I will file the patent for that. It might happen that sometimes from the universe, from the world, anybody can apply patent for that technology. So in that case, you will not get benefit for that. You cannot get any patent for that. Okay. So again, next is design. So design means it has to do with design is for any article, not software article. It is hardware article. Okay. So design means any shape, configuration, pattern, or ornament, composition of lines or colors or combination thereof applied to any article, which is 2D or 3D article or in both. Okay. So we will see one by one shape and configuration. So what is the importance of this? Suppose that two companies are there and they have equal price because due to their technology they have the equal price. Okay. But one has better design. So of course public and customer will go with the better design. So in that case design is the only differential matter that matters. This is a trial design. So many designs are going on in washroom, in brush, mobile. You will say daily you will say new types of design. Now this is the technical point. It will be applied to 2D or 3D or in both forms. First thing. Second thing that finished article. The article should be finished. It should not be a raw material. And it has to be judged solely by the eyes. Judgment will be done by looking from the eyes only. Okay. And it does not include any constructional feature. It does not include any technical feature. Okay. We don't have to do, in case of design, nothing technical feature is required. Just by looking at from the eyes that it is new, it is original or not, it is new or not. So constructional, textile or technical features are not considered as design. Terms of protection is 10 years and it can be extended for 5 years to total 15 years. Now the thing is that you have to pay the renewal fees. Each and every year you have to pay the renewal fees, otherwise your design registration will not be in force. Now what are the importance of design? So one thing is that it is a unique selling point. Okay. Sometimes second thing is that if you have made any good design, new design, then you think you want that design should be known publicly to all. So when you will file for the design registration, it will be get published and after publication all person can know this. सभी लोग को पता चल जाएगा जब ये डिजाइन ऑफिस में ये फाइल होगा, क्योंकि ऑफिस उसको पब्लिश करेगी किसी अपोजिशन के लिए, किसी को कोई अपोजिशन है, किसी को कोई प्रॉब्लम है तो वो अपना अपोजिशन फाइल करे। सो इन दैट केस यू विल गेट द बेनिफिट दैट सभी को पता चल जाएगा कि इतना अच्छा डिजाइन आया हुआ है। सो द एनी कंपनी कैन मेक अ कॉन्ट्रैक्ट विथ यू। ओके, सो इट्स एड वैल्यू टू अ प्रोडक्ट, you will get a good return on your investment and it may become a business asset. So why registration is important? अगर आपके इलाका में कोई भी ओरिजिनल या कुछ यूनिक डिजाइन है फॉर विच आपको लगता है कि उसको नेशनल इंपॉर्टेंस मिलना चाहिए, सो इट मस्ट बी रजिस्टर्ड। ओके, सेकेंड थिंग इज दैट इमिटेशन से बचने के लिए मीन्स आपके प्रोडक्ट का इमिटेशन ना हो। आप ये चाहते हैं कि मैंने ये जो प्रोडक्ट बनाया है इसका इमिटेशन ना हो, इसका कॉपिंग नहीं हो सके, तो व्हेन यू विल फाइल देन इन दैट केस नोबडी विल गोइंग टू इमिटेट दैट एंड आप अगेन आप कॉमर्शियल बेनिफिट गेन कर सकते हैं बाय साइनिंग एंड लाइसेंसिंग योर राइट। ओके, these are the application small scale and big scale industry. You now see that in every space, in every field, design is very important. The cost is deciding just by the design. This is the T set. Okay, this is hand sanitizer in pharma product. Although pharma product is also dealing with too much of patents, but good design, same sort of medicine, but the different companies, they come with the different designs. Okay, so better the design, more will be the cost of that product. And you know, textile and jewelry industry works on the basis of only design aspect. Okay, design is the only single point tool which is important in that case. These are the another customer products. These are the other safe configuration surface pattern of bottles. This is toy industry, which is also works on the design pattern. Now see, this is an invention of a traffic signal, patented in 1923. Such a small invention, and he has saved millions and millions of lives. And not in today's scenario, in future also it will save millions and millions of lives. सो यू नो इनोवेशन एंड साइंस, आप बोलते हैं साइंस वरदान है, तो उसका ये एक एग्जांपल है। सो द थिंग इज दैट इफ एनीथिंग इज यूजफुल टू द सोसाइटी, कोई भी चीज सोसाइटी के लिए यूजफुल है, अगर वो टेक्नोलॉजी सोसाइटी को समझ में आ रही है, देन नोबडी कैन स्टॉप हिम। ओके, अब ये देखिए, ये इसने स्टार्टअप स्टार्ट किया, इट इज अ बिजनेस ऑनर स्टार्टअप ऑन द बेसिस ऑफ डिजाइन, बाय मेकिंग अ क्रिएटिव डिजाइन, बाय मेकिंग अ यूनिक डिजाइन। ओके, these are the all registered designs. These are the again examples of registered design. See, this design has been made by National Institute of Design, NID, Ahmedabad. Now come to the trademark. So trademark can be given to trade name, trademarks, collective marks, certification marks, taglines, slogans and sale. आपने IPL का मैच देखा होगा, in that IPL match you will hear a particular type of sound, so they have trademarked that sound. जब आप अपना विंडो ओपन करेंगे, there is also in your computer there is also a background music. In कौन बनेगा करोड़पति, you will also hear a background music. So all these are trademarked sound. Now a trademark can be a word, a design, or even a website name, a slogan, a symbol. Anything can be a trademark, a picture, a logo, but it should not be descriptive, because it is a thing that just by looking from the eyes, it should be clear that it should get the reflection that this is your product. Okay. So visual symbol may be word, name, symbol, indicate the source of the goods. Okay, it must indicate the source of the good, and it must be distinguished from the goods of the others. Now, generally, you will see two types of marks. Uh, how they will for one is R with a circle and another one is TM. R with a circle means they have applied the trademark and they have got the registered. Okay. Second one is TM. TM means trademark has been applied and it has been unregistered. They have not get the trademark for that. Duration of time is 10 years and it can be renewed 10 years subject to the uses. अगर use है तो आप करा सकते हैं and indefinitely, there is no time limit. Okay. Now, trademark registration is optional. It is not compulsory that you want the trademark logo. But if you will make it, there are certain advantages. Advantages is that nobody can use it. Originality can be kept. Original product, if you will get the logo, trademark registration logo, then everybody will understand that this is a genuine product and imitation can be stopped. Okay. And trademark is governed by the Trademark Act 1999 and Trademark Rule 2017. And in case of non-uses, non-renewal or no polishing, trademarks rights will be lost. Okay. Now, the next thing is geographical indication. Geographical indication means if there is something unique in your locality or anything is new, which is not known to everyone. So in that case, you can take geographical indication for that. For example, Darjeeling tea. जब दार्जिलिंग का टी बोलते हो तो हम लोग किसी पर्सन को नहीं जानते, हम लोग दार्जिलिंग के कम्युनिटी को जानते हैं कि जहां से वो टी आती है. कांचीपुरम सिल्क, शाही लीची और मुजफ्फरपुर, तो ये उस जगह को बताती है. आगरे का पेठा, नागपुर के संतरे, ये उस कम्युनिटी को बताती है, उस लोकेलिटी को बताती है. सो इफ देयर इज यूनिक इन योर कम्युनिटी, इन योर सोसाइटी, आपको लगता है कि इसको मिलना चाहिए, इसको यूनिकनेस होना चाहिए, तो आप उसको चेन्नई पेटेंट ऑफिस में फाइल कर सकते हैं. एंड ऑफिस विल ऑफर द विल कॉल द ग्रुप ऑफ योर ग्रुप ऑफ पीपल एंड यू हैव टू गिव द प्रेजेंटेशन. And if you will succeed, then you will get the certificate of the geographical indication. And term is 10 years and it can be extended up to 10 years and subject to the uses. This is Darjeeling tea, known by the Darjeeling area. This is Makrana marble from the Rajasthan, Ratlam Sewab from the Madhya Pradesh, Kanchipuram silk from the Tamil Nadu. And this is Katputli of the Rajasthan, Bagh print of the Madhya Pradesh, Bengal Patachitra, Cheriyar painting, Warli painting, Shahi Lichi of the Bihar, Kurg orange, Nagpur, Maghi pan, Kashmir saffron. Okay, so these are the few examples of geographical indication. अब हम लोग कॉपीराइट की तरफ आते हैं. सो सी कॉपीराइट, अब जैसे कि हमने देखा पेटेंट और डिजाइन ये टेरिटोरियल राइट थे. अगर आपने इंडिया में फाइल किया है तो यू विल गेट बेनिफिट इन इंडिया ओनली. बट ये कॉपीराइट जो है ना, ये इसका वर्ल्ड वाइड राइट मिलता है, यूनिवर्सल राइट मिलता है. इसका राइट सिर्फ आपको इंडिया में नहीं मिलेगा, पूरे वर्ल्ड में मिलेगा. जिसने भी बर्न कन्वेंशन साइन किया है, बर्न कन्वेंशन जिसने भी साइन किया है पूरे वर्ल्ड में, सभी पे यूनिवर्सली एक्सेप्टेड है. अगर आपने कुछ यूनिक बुक लिखा है, जैसे कि आपने देखा होगा RS अग्रवाल मैथमेटिक्स का है, RD शर्मा मैथमेटिक्स का बुक है, SC वर्मा फिजिक्स का बुक है. आपके भी फील्ड में बहुत सारे रिनोन्ड राइटर्स होंगे. दे विल गेट द रॉयल्टी अप टू हिज होल लाइफ, एंड आफ्टर देयर लाइफ, देयर नेक्स्ट जनरेशन, दे विल आल्सो गेट बेनिफिट फॉर नेक्स्ट 60 years. So if you have any good book inside you and you think that is helpful to the society, so you must come with that. और ये कॉपीराइट कैसा होता है कि जैसे कि अभी आपने एक पोयम लिखा, या आपने कुछ डिश बनाई, या आपने कोई सॉफ्टवेयर प्रोग्राम लिखा, तो ये फ्रॉम दैट टाइम ओनली यू हैव द राइट ऑन इट. आपको कॉपीराइट ऑफिस जाने की कोई जरूरत नहीं है कि हमने ये पोयम लिखा और हम लोग कॉपीराइट ऑफिस चले जाते हैं. हमें इसका वो चाहिए, प्रोटेक्शन चाहिए, नो नीड. So it provides to the holder from the first day only. Okay, and right is restricted, and it is unauthorized copying and reproduction of original expression. Copyright protection इन सारे literary work, artistic work, dramatic work, musical work, sound recording work, cinematography film, ये इस फील्ड में मिलते हैं. इसका ये मतलब है इसके लिए कोई इंडस्ट्री की जरूरत नहीं है, इसके लिए इंडस्ट्रियल प्रॉपर्टी से इसको डिफरेंट किया गया है. दीज आर द सेक्शंस which will deal with all these copyright work. Now this is an example. This is a Sony television. This Sony television has LED screen and remote control. Both are technology. So they have filed the patent for that. And this Sony, they have applied for trademark because of unique style of writing. And this has aesthetic look. So he has filed design application for this. And since you will purchase any electronic item, they will give you the user manual, how to operate this this device. And they have filed copyright for this. Since they have created this, so they have the copyright for this. See the single product, 4 types of protection. So that is the usefulness of, and this is the creativity of mind. Okay, he can also apply for the semiconductor integrated circuit layout, because in every electronic gadget there is certain circuit design. उसके बिना ये सिस्टम नहीं चलेगा. Now this is when you will, आप कभी डोमिनोज गए होंगे, आप डोमिनोज के ऑनर से पूछिएगा कि आपने इसको बनाया कैसे, तो आपको कभी नहीं बताएगा. वो बोलेगा कि सर सॉरी, दिस इज आवर ट्रेड सीक्रेट, वी कैन नॉट रिवील विथ यू. आफ्टर दैट ट्रेडमार्क इज देयर. सिंगल प्रोडक्ट डोमिनोज का ट्रेडमार्क है, उसका इंडस्ट्रियल डिजाइन है, उसी डिजाइन का वो सेब का पिज्जा बनाएगा जिस डिजाइन का उसने रजिस्ट्रेशन ले रखा है. If you feel any technology, he can file patent for that, and of course copyright is there also. So a single product and so many intellectual property rights. Similar example here also, similar example here also. Now the next thing is that what can you do with the IPR? So if you are a science graduate or engineering graduate, you can become an examiner of patents and design. I have also joined this office as examiner of patents and design. Now I am assistant controller of patent and design. And if you have a law graduate degree, then you can also become an examiner of trademark copyright graduate. Okay, if you can have a law degree, you can participate in IPR policy. You can participate in you can work in an IPR firm, NGO firm, IPR cell. Okay, and you can also join government offices. So these are the some few career opportunities with intellectual property rights. So what can you do? By a simple approach, so many thousands of scientists, faculties can become an inventor. So what is going on? Identify any problem. If you are facing any problem, solve that problem, and you can apply for the patent or design anything. And when you will file before publication, nobody is going to see that. That is NDA, non-disclosure agreement with the office. And what can be patented? Any process and product that should be new, involving inventive step, that has to be capable of industrial application, and not barred by section 3 and 4. Section 3 and 4 is a very section 3 is a very big section. You can go through the Google and write section 3 of Indian Patent Act. You will get all the details. Section 4 is related with the atomic energy. Atomic energy related invention is not allowable in India. And the product includes apparatus, machines, device and chemical products. Okay. And newness, I just explained what is newness. Means that is not in the public domain. आपके application file करने से पहले वो public domain में नहीं होना चाहिए. वो या तो ट्रेडमार्क हो, या कॉपीराइट हो, या डिजाइन हो, या पेटेंट हो, कोई भी चीज हो, आपके फाइल करने से पहले वो पब्लिक डोमेन में नहीं होना चाहिए. दैट इज द मीनिंग ऑफ न्यूनेस. इन्वेंटिव स्टेप जहाँ लाई करता है कि उसमें कुछ टेक्निकल इम्प्रूवमेंट होना चाहिए। जैसे किसी ने कोई ड्रग बनाया तो ड्रग बनाने में 5 स्टेप का केमिकल रिएक्शन लगा। नाउ ही इज गोइंग टू रिड्यूस फ्रॉम 5 to the 2 step only, और it also possible that वो 5 step ही लिया but improves the efficiency of that thing. So that is the meaning of inventive step. And now these are the some indications of the non-obviousness. कोई सरप्राइजिंग रिजल्ट आपको मिलता है कुछ काम करते हुए, या फिर कोई बहुत लंबा प्रॉब्लम था उसका आपको कोई सॉल्यूशन मिला, ओके, और फुलफिलमेंट ऑफ अ लॉन्ग फेल्ट नीड, and if there is any great technical progress. These are the indications of the non-obviousness. And industrial application means it has to be used in industry, or it can be made in industry. These are the essential ingredients of the complete specification. Okay. These are the types of claim: independent claim and dependent claim. Independent claim में सारे जनरल फीचर होने चाहिए, और उसको डिफाइन करने के लिए हम लोग मल्टीपल डिपेंडेंट क्लेम बनाते हैं। ओके, ये एक एग्जांपल है, ये केमिस्ट्री से रिलेटेड है। दिस इज अगेन एन एग्जांपल, एंड ये देखिए, दिस इज आल्सो अ वे ऑफ राइटिंग अ क्लेम। क्लेम आप लिखते कैसे, क्योंकि पेटेंट आपको मिलता है क्लेम के लिए, आपको कंप्लीट स्पेसिफिकेशन के लिए पेटेंट नहीं मिलेगा। आपको जो आपने क्लेम किया है, व्हाट इज योर क्लेम, ओके, आपको सिर्फ उसी के लिए पेटेंट मिलेगा। तो इसने जैसे कि फार्मास्यूटिकल कंपोजिशन ही हैज मेड विद कंप्राइजेस एजिलास्टीन और साल्ट, तो ये उसी कंपोजिशन को ये एक्सप्लेन करेगा। अब ये कह रहा है कि ये एक्वस सॉल्यूशन भी हो सकता है, कि एरोसॉल भी हो सकता है, ये पाउडर फॉर्म में भी हो सकता है, ये जो कंपोजिशन है। सो इसी को इन्होंने और एक्सप्लेन किया, और दे हैव यूज्ड द एस्टेरॉइड, और ये एस्टेरॉइड को इन्होंने फिर डिफाइन किया कि इनका एस्टेरॉइड कैसा होगा। तो पहला क्लेम काफ़ी जनरल था, उसको इन्होंने नैरो डाउन करते चले गए। दैट इज द वे ऑफ राइटिंग एनी क्लेम। पेटेंट फाइलिंग, कोई भी नेचुरल और इंडिविजुअल पर्सन पेटेंट फाइल कर सकता है। एनी लीगल एंटिटी कैन फाइल, एनी स्मॉल एंटिटी कैन फाइल, और स्टार्टअप और कैन ज्वाइंटली फाइल विथ स्टार्टअप विथ कर सकता है, और स्टार्टअप इन सब के कॉम्बिनेशन के साथ भी पेटेंट फाइल कर सकता है। You can file physically and with electronic filing. Our office works on the both mode. Online filing, there is 24/7 into 365 days it is open. You don't have to wait to the office to be open. And offline filing, of course, fees is 10% extra. It is being done to encourage more and more online filing. These are our offices, jurisdiction area wise. So we are from the Bihar, Patna. So we will come in the jurisdiction of Kolkata. Okay. And if you want, so these are the other offices: Mumbai, Chennai, New Delhi. And in design application can be filed in the Kolkata office. Okay. So these are the documents which is required for the filing. You have to give the form 1, in which every details of the applicant have to be given, in which proof of right has to be given under paragraph 9 of form 1. Provisional or complete specification, you have to give a statement of the foreign filing. If you have filing outside India, you have to give in form 3. Declaration as to inventorship you have to give. Request for examination you have to give in form 18. Drawings, if any, you have to disclose. Abstract of invention you have to disclose. Fees, and send by post or a counter, or online you can give the fees. If you need any early publication, form 9 is there. For power of attorney, form 26 is there, and certified copy of convention application if required, you can file it. Okay, and the fees is 1600 for the natural person, 8000 for the others, and up to 30 pages there is no fees for filing your application for the complete specification. And if you will file more than 30 pages, so for each page 160 rupees is there, and 8000 is for the natural for the company. And for claim addition to 10 क्लेम से ज़्यादा होगा तो 320 रुपीज़ देना है ईच क्लेम के लिए, और कंपनी को 1600. नाउ द इंस्टीट्यूशंस लाइक यू, उनके लिए 80% कंसेशन किया गया है फीस में. सपोज दैट ये 1600 नेचुरल पर्सन का कंपनी का था, इसका 20% कितना होगा 320. सो नाउ दिस इज द फीस ऑफ द इंस्टीट्यूट्स ऑल्सो, सो दैट मेक encouragement फॉर द फाइलिंग. फॉर्म 18 आपको फाइल करना होगा, इसके बिना आपका एप्लीकेशन रिक्वेस्ट एग्जामिनेशन नहीं हो सकता है. 4000 is the fees for the natural person, 20,000 fees for the other than natural person. Form 9 we have discussed, fees is 2500 for the natural person and 12,500 for the other than natural person. Form 9 5 करने के बाद आपका जो एप्लीकेशन है वो 1 month के अंदर पब्लिश हो जाएगा. और एक्सपेडाइट एग्जामिनेशन आप लोग अभी फाइल कर सकते हैं, सिंस ऑफिस वर्क्स ऑन द प्रिंसिपल ऑफ फर्स्ट कम फर्स्ट सर्विस बेसिस. बट लेकिन आप चाहते हैं कि आपका ऑफिस वर्क पहले हो, तो आप फॉर्म 18 डाल करके आप अपने एप्लीकेशन को एक्सपेडाइट करा सकते हैं. सो उसके लिए है कि अगर आपने इंडिया को एज ISA सेलेक्ट किया है इन PCT फाइलिंग में, इफ़ कोई एप्लीकेंट जो वो फीमेल है उसके लिए भी ये प्रोविज़न है, और एप्लीकेंट अगर स्टार्टअप है या स्मॉल एंटिटी है तो उसके लिए भी ये प्रोविज़न है. फीस इज 8,000 फॉर द नेचुरल पर्सन एंड 60,000 फॉर अदर देन नेचुरल पर्सन. Now various forms are there. So this is the form and fees. When you will click on this, you will enter. This is also available in IP India websites. Okay. And online can be filed. You can file your application online. This is online filing portal. You will file online application here. Now this is the procedure of filing. Digitization will be there when we will file your application. Offline filing, digitization will be there. After that, screening and classification. So if it belongs to atomic energy or defense, it will go to that section. After that, classification will be done in the mechanical, electrical, chemistry, biotech. After that, if you have filed form 9, early publication, otherwise publication after 18 months. Request for examination time is 48 months. Allotment will be done after you will file form a request for examination request. It will go to the examination and you will get the first examination report. After that, 6 + 3 months of time you have to give the correspondence reply. After that, it will be granted or refused. And before this time, you can file a pre-grant opposition. And after grant, it will be published. And after publication, within 1 year, anybody can file the person interested will file the post grant, and pre-grant will be filed by any of the interested person. Any person can file pre-grant, but post grant will be filed by interested person only. Okay. Now these are the roles of the IPR: encouragement for the improvement of technology, providing rewards as exclusive rights for disclosure, and after 20 years you have to transfer your right to the public. Okay. So what to do? So suggestion is there. Suggest share benefits of patent system, utilize resources through R&D, organized R&D activities. What are the requirement of the global capture market? You have to capture that and earn through the protected market, means while you will making the red ocean. Okay. So thank you. So I want to move to you. If you have any question, you please ask.
2 minutes. Any questions?
Hello. Good afternoon, sir.
Good afternoon, sir.
I wanted to ask if digital signatures can be trademarked or not.
Digital signature, it is not a trade symbol. Because digital signature is a thing of certain individual thing. So this is the signature of anything individual. It cannot be trademarked. It cannot be a commercial thing. So digital signature cannot be trademarked because anybody can do signature in any way. then you will say that every signature is he is copying my signature, pattern of signature is same.
Sir, I'm not talking about digital signature in anyone can do. I'm talking about those who work in public offices. Uh, I've given the exam of Triple C through NILATE and received the certificate. There was a digital signature signed by competent authority. So I'm talking in that sense.
See, there are two things. One thing is that you are saying about e-sign, e-hastakshar is there. One is second one is digital signature. Both are different thing. So if you are talking about digital signature in terms of in terms of legal, you are saying, or for the academic purpose, because when you will file the online filing in the Indian patent system, then you also need the digital signature, but that is different from the e-sign or e-hastakshar. So that digital signature can be made by an agent or by an authority. So because it is just if you are talking about the institute will disclose that what type of digital signature is being required by them.
Sir, DSC, digital signature certificates.
Digital signature certificate. Actually, I don't have too much. I have not done too much research on digital signature. I have the just basic idea regarding that. So digital signature certificate, that is, I am not aware of that thing.
Okay.
Hello, Mr. Ravi. What exactly are the inherent advantages of filing through WIPO, World Intellectual Property Organization?
Please say, speak loud. I am not listening.
What exactly are the inherent advantages of filing through WIPO, World Intellectual Property Organization?
Filing of advantages WIPO. Very good question. Actually, see, देखिए सर, हम लोग पेटेंट क्या है ना, वो टेरिटोरियल राइट है, और टेरिटोरियल राइट होने का ये मतलब होता है कि आप अपने कंट्री में तो फाइल कर दिए, नाउ यू हैव टू एंटर इनटू द एरिना ऑफ द डिफरेंट कंट्री. आपको दूसरे कंट्री में जाना है, तो आप कैसे जाइएगा? आपको दूसरे कंट्री में फाइल करना है. तो पूरे वर्ल्ड ने ना वो एक रास्ता बनाया है. दे हैव मेड पीसीटी, पेटेंट कॉर्पोरेशन ट्रीटी, ओके, एंड इंडिया इज ऑल्सो सिग्नेटरी ऑफ पीसीटी. सो व्हेन यू विल चूज, जब आप पीसीटी में इंडिया को एज अ कंट्री सेलेक्ट करेंगे, तो वो आप एक्सपेडाइट फाइल कर सकते हैं. वो एक सेपरेट इशू है. बट आप जेनेवा में, स्विट्जरलैंड में इसका ऑफिस है. अगर आप वहां पे फाइल करते हैं तो आपको 31 मंथ का प्रोटेक्शन मिलेगा, प्रायोरिटी मिलेगी. उसके बाद यू कैन इंटर इनटू एनी ऑफ द पीसीटी कंट्री. जिन्होंने उस ट्रीटी को साइन किया है, जिन्होंने उस एग्रीमेंट को साइन किया है, उसके 31 कंट्री में किसी भी कंट्री में आप इंटर कर सकते हैं. सिमिलरली पेरिस कन्वेंशन भी है, उसमें लगभग 180 कंट्रीज है. पेरिस कन्वेंशन में अगर आप इंडिया में फाइल करते हैं तो उसमें 12 मंथ्स का टाइम होता है. 12 मंथ्स के टाइम के अंदर आप पूरे जितने भी कंट्रीज ने पीसीटी का साइन किया है, आप किसी भी कंट्री के अंदर आप विद इन 12 मंथ्स आप इंटर कर सकते हैं. ये आपको एक प्रायोरिटी, एक प्रिविलेज दी गई है. जैसे यूनाइटेड स्टेट भी मेंबर है इसका, तो वो अपने सिटीजन्स को जो बेनिफिट देती है वही बेनिफिट वो आपको भी देगी. वो सारे प्रोटेक्शन और प्रायोरिटी वो आपको भी देगी, और हमें भी देना होगा जब उनके सिटीजन्स अपना एप्लीकेशन हमारे कंट्री में फाइल करते हैं. सो दैट इज द मीनिंग ऑफ रेसिप्रोसिटी. ओके.
I have one question. Do you have any state-wise breakup of the patents being approved by office? So the कौन सा state कहाँ stand करता है in terms of patent approval, and where does Bihar stand if you have?
Actually ये डेटा तो है हमारे पास, लेकिन अभी मेरे पास अवेलेबल नहीं है. वो मैं टेक्निकल टीम में काम करता हूँ, और ये रेक्स डिपार्टमेंट होती है, वो फॉर्मल टीम होती है. उनके पास ये डेटा होता है कि कौन से स्टेट का कितना पेटेंट ग्रांट हुआ है. और अभी मेरे पास वैसा कोई डेटा अभी मेरे पास है नहीं, लेकिन बट यू विल फाइल अ रिक्वेस्ट, वी कैन फॉरवर्ड इट. so that if there is any data.
और
So
दूसरी बात
एक्चुअली हम लोग अभी नेशनल लेवल पे बात करते हैं कि इंडिया में इतना पेटेंट फाइल हुआ, इतने पेटेंट ग्रांट हुए। अभी तक डेटा वैसा बनाया नहीं है, क्योंकि किसी ने शायद पूछा नहीं होगा, या पार्लियामेंट की तरफ से भी ये क्वेश्चन नहीं आती है। जब उनकी तरफ से क्वेश्चन आती है तो फिर हम लोगों को वैसा रिस्पॉन्स देना पड़ता है कि स्टेट वाइज कितने पेटेंट ग्रांट हुए। और इवन पेटेंट फाइल करने के लिए क्या करते हैं कि सभी जितने भी वो है ना, स्टेट गवर्नमेंट वो ये देती है, वो इंसेंटिव्स देती है आपको कि आप पेटेंट फाइल करें। वो जितने भी स्टेट गवर्नमेंट है, सेंट्रल गवर्नमेंट की तरफ से भी इंसेंटिव दिया जाता है। तो हमारे पास डेटा अभी नहीं है ऐसा, तो हमारे पास अभी तो कोई वो बड़ी ये नहीं है, हम भी हैव टू कलेक्ट इट।
और जो दूसरा कनेक्टेड ही क्वेश्चन है कि पूरे नेशनल लेवल पे स्टार्टअप्स पे बहुत कुछ है, हर स्टेट गवर्नमेंट मोर एंड मोर स्टार्टअप्स प्रमोट कर रही है। तो उन स्टार्टअप्स में अगेन वो डेटा रिलेटेड ही क्वेश्चन है कि उन स्टार्टअप्स में कितने पेटेंट रिलेटेड स्टार्टअप्स होंगे, पेटेंट अप्रूव्ड होंगे। मान लीजिए
अभी देखिए, अभी मैं बताऊं तो पेटेंट रिलेटेड स्टार्टअप बहुत सारे आ रहे हैं। हम लोग स्टार्टअप के लिए ना, अभी मैं फॉर्म 18A डिस्कस किया था, एक्सपेडाइट एग्जामिनेशन। जितने भी सारे स्टार्टअप आ रहे हैं ना, वो सारे क्या कहते हैं कि वो सारे पेटेंट के लिए फाइल कर रहे हैं। अभी बहुत सारे स्टार्टअप आ रहे हैं, मतलब कि समझ जाइए कि अभी अराउंड 30-40,000 एप्लीकेशंस जो होंगे टोटल में। मैं अभी मतलब वो एनुअल नहीं कह रहा हूँ, मतलब 4-5 साल का फिगर है, तो उसमें इतने एप्लीकेशन आराम से होंगे स्टार्टअप की। काफ़ी फाइलिंग हो रही है स्टार्टअप की, बट एज एट दिस प्लेटफॉर्म आई हैव टू टॉक विद द कंक्रीट डेटा। सो मेरे पास भी वो डेटा नहीं है। सो हाँ, बट वी कैन कलेक्ट इट, इट्स नॉट अ बिग थिंग।
Any other questions?
No.
Huh? No? So I think there are no more questions. So thank you very much, Rajaji. Thank you very much for sensitizing the topic, intellectual property rights. I hope the young minds, once they are sensitized, and in future if they come across any such idea which they believe that can be patented or can be commercialized in future, so I think they will certainly take the advantages and benefits of patenting those ideas, and will take benefits out of that. Thank you very much for your sensitization. Thank you very much.
Thank you, sir. And I also request you that I have sent a feedback form. So please, you all participants, please fill that feedback form. And
Sure.
because that before we can do any appreciation certificate, every detail should be written correctly there. So because this will directly come to our office when you will fill this feedback form. So that is will be given you as an appreciation certificate.
Yes,
And,
we have received
and coordinator
that.
will coordinator
received
will
that link.
get the separate certificate also.
Fine. So I'll share the link with the participants here, and I'll ask
Okay.
them to fill the form and send it across. Thank you very
Okay,
much.
sir.
Ravi.
Okay, thank you, sir. Thank you.
Let's go now. So you want, some leadership lecture series to happen? Fine. So thank you very much. Thank you very much for your cooperation, your patience. We'll meet tomorrow again, same time, same place.